Hello, everybody. Welcome to this series of videos that I'll be recording on court interpreting. In this first video, I just want to talk a little bit about the different types of courts that we have in Scotland. I want to talk about the different type of hearings we have in summary procedure cases. And for those of you who might be new to court interpreting, the kind of jobs that you might be looking at accepting initially um, when you first offered court work, because they might be slightly easier jobs to start with. So I'm going to start off by showing you this diagram here, and this is basically an explanation of how cases of the different types of courts we have in Scotland, but also how cases are allocated to different courts. So we've got in Scotland an organisation called the Crown Office and Procurator Fiscal Service. And that's a joint body. So the Crown Office prosecutes solemn cases, in other words, more serious cases, and the Procurator Fiscal prosecutes summary cases, which are, typically less serious offences. So whenever the Procurator Fiscal, talking specifically about summary procedure, whenever a Procurator Fiscal has a case, they can make a decision whether to prosecute that case or not. And if they decide to prosecute the case, they then allocate it to the most appropriate court. And generally speaking, the rule of thumb is that they'll allocate it to the lowest possible court that has enough powers to sentence the accused in case he's found guilty. And we've got this three-tier hierarchy in Scotland. So at the bottom, we've got the Justice of the Peace Court. So this is the lowest court in Scotland. And by the way, we're talking here specifically about criminal cases, not civil cases. That's slightly different, but in this video, we're talking specifically about criminal cases, because that's what we as public service interpreters tend to encounter in the most of the time. We rarely get to do civil things. So at the bottom here, you've got the Justice of the Peace Court. Then you've got this court here, which is, you could call it the middle tier courts, the sheriff courts. And at the very top, you've got the High Court, which deals with the most serious offences that people are prosecuted for. So we've got these three-tier system. However, I actually normally like to think and talk about this hierarchy as a four-tier system, where at the bottom you've got the Justice of the Peace Courts, and then you've got the Sheriff Courts and the Summary Procedure, the Sheriff Court and the Solemn Procedure, and the High Court. So what is Summary Procedure and what is Solemn Procedure? Well, in simplistic terms, summary procedure is basically when a case is heard just by a judge or a justice of the peace. And in solemn procedure, a case is heard with a judge and a jury of 15 people in Scotland. Okay, so and basically what this diagram here shows us is that the justice of the peace court always runs under summary procedure, so you never get solemn courts in the JP court. The High Court always runs under solemn procedure. So in other words, High Court trials always have a jury. And the Sheriff Court and cases in the Sheriff Court may or may not have a jury, depending on the seriousness of the case. So you've got basically really a four-tier system, because the Sheriff Court can have cases under summary procedure or solemn procedure, depending on the seriousness of the offences. So we will look at solemn procedure in another video, but just now we're going to talk about summary procedure. So summary procedure, as you can see, are less serious offences dealt with by the lower courts in Scotland. And really, if you don't have any experience interpreting in court, these are the kind of jobs that you want to start with. Just because they're less serious, there's less pressure. Hearings tend to be quicker, quite often less technical, not always, but quite often less technical, a little bit easier to deal with, a little bit less challenging. Now, when I was showing you this diagram here, so when the Procurator Fiscal assign a case to a court, the accused doesn't just, the case doesn't just go immediately to trial. There's a few, there's a sequence of hearings that take place before the trial and if potentially even after the trial. So I wanted to explain these to you because actually, as public service interpreters, trials are only a very small proportion of the work we do. I would say 1 in 5, 1 in 10 jobs we do, probably even less actually, are trials. The rest are different types of hearings. So whenever you're offered a court job, the likelihood is that it will not be a trial. So I wanted to start off by, in a summary case, this is basically the sequence of hearings. So the first hearing you get in a summary case is this one, called a pleading diet, also commonly referred to as a custody hearing. Normally agencies refer to these as custody hearings, or quite often even just custodies. And this is the first hearing of the accused in front of a judge after he's been charged of a crime by the police. And this is a procedural hearing, so no evidence is led in this hearing, and this hearing serves basically two purposes. The first purpose is to ask the accused how does he plead to the charges, guilty or not guilty. And the second thing that's discussed is whether the accused can get bail or not pending trial. If the accused pleads guilty, then he can be sentenced there and then, or as you can see in this dotted line here, the case can be adjourned for a separate sentencing diet or sentencing hearing. This is unlikely, and this would only happen, the case would only be adjourned for separate diets if if the judge needed to get social background reports. In the vast majority of cases, if a judge can't sentence an accused at a pleading diet, they will, in the name of expediency. So if the accused pleads guilty, that's the end of the case. It doesn't go any further, and the accused is sentenced. If the accused pleads not guilty, then the case goes on to the next hearing in the case, which is the intermediate diet. Once again, the intermediate diet is a procedural hearing, and no evidence is led, no witnesses are called, and it serves two purposes. Once again, first of all, whether the accused can continue to get bail or not, or if he didn't get bail before, whether he can get bail now. And secondly, whether both parties are ready to proceed to trial. And that's really its main purpose, basically to avoid a situation where a trial calls and one of the parties is not ready and they have to adjourn again. And trials are very costly to run. So to have a situation where a trial is adjourned is not ideal. You've got witnesses being paid expenses, you've got court time that's wasted, and so on. So this hearing actually serves a very important purpose in the criminal justice system. If the accused pleads guilty at this stage, he's sentenced, or he can be adjourned for a separate sentencing diet, as you can see. If he pleads not guilty, the case then goes on to trial. And by the way, you can get multiple intermediate diets, so you can get continued intermediate diets. So if one of the parties is not ready to proceed to trial, and they're not sure whether they would be ready by a certain date, for example, the judge could just recall the diet on another date to continue the intermediate diet, to check at that later date whether both parties would be ready to proceed to trial. Okay, so you can get multiple of these intermediate diets. Typically no more than 2 in a summary case, but technically it could be more. The case then proceeds to trial, and most people will understand what a trial is. There's other videos in my YouTube channel that show you mock trials taking place. There's one video that shows you a summary trial in a JP court where an interpreter is used. There's another video that talks about a sheriff and jury trial. So you can watch those if you want a little bit more information about what actually happens, during a trial. And at the end of the trial, the accused would be the judge or the jury would pass a verdict, and the accused would then either be released or sentenced if convicted. And if the accused is convicted, the sentence can be passed once again there and then, or it can be adjourned once again to a separate sentencing diet. So I mentioned before that normally they only adjourn for a separate sentencing diet in summary cases if the judge needs to consider obviously the circumstances of the accused and of the offense and what sentence to impose, but also if they need to obtain social background reports. And normally they do that if they've got someone who's been who's just been convicted of a crime, but that person has never been to prison before, but the judge is considering a prison sentence for this particular offense. So the judge is not allowed to send someone to prison who's never been to prison before without first getting social background reports. And this is for the purpose of ensuring that the judge passes an appropriate sentence. So these are really just the four hearings that you would get in a criminal case. Now, as a public service interpreter, what jobs do you want to start with? Well, ideally, you want to start with these here, pleading diets, because they tend to be a little bit quicker. They're over, it's a procedural hearing. They're over very quickly. They serve two purposes, as I mentioned before. There's not much you can do wrong, and everybody's nervous in their first job, so it's the kind of thing you want it to be over quickly. Intermediate diets as well. They can be, the procedural hearings. By nature, they don't tend to be very technical. Obviously, there's always exceptions to the rule, but generally speaking, they don't tend to be very technical. They're talking about practical issues like contacting witnesses and collecting evidence and so on and so forth. And sentencing diets can be quick as well, although they can be a little bit more complex because the judge can go into the circumstances of the offense and occasionally into relevant law and so on and so forth. And obviously trials are a bit longer, so they can be a little bit more challenging if you're not used to to interpreting for any great length of time, and also if you're nervous, if it's your first time being in a court. A trial is probably not ideal, just because you really want to have calmed those nerves before you start doing a trial. But it's not to say that your first job can't be a trial. My first job many years ago was a trial. So yeah, so this is it. Ideally, as an interpreter, first job, pleading diet, but sometimes you might just have to take what you're offered. So I hope this video was useful. If you like it, please give me a like and follow my channel, and watch out for the next few videos in the series where I'll be talking about solemn procedure and other aspects of court interpreting, like court etiquettes, best practice guidelines, some of the most common issues you can encounter in court, some of the terminology, in most common terminology you will encounter to help you prepare for your court assignments. Thank you very much for watching. Goodbye.